All right, good morning.
Good morning, Judge. How are you?
Good.
Morning.
I don't know, how am I guess is the
I
question.
think we're good.
Okay.
Your Honor, the Commonwealth has elected to proceed on one count of aggravated within 3 years and one count of aggravated, same transaction. We have presented one instruction for each of those
Perfect.
counts. It is the model. We
Perfect.
have added to that one instruction that had not been previously provided for child endangerment. We will not be
Right.
going forward
And I'm
on
going to take out the child abuse one,
abuse and
correct?
neglect, exactly.
Okay.
And then we have withdrawn, and I can tell you which letters,
Okay,
instructions
Alright.
that were related to
Sure.
first degree, second degree.
let me, hold on a moment, just for the record, which counts of the 4 counts of aggravated murder are you going forward on?
One moment.
Either 1 and 3 or 2 and 4, I think those are the options.
Right.
But I just want to make sure for the record.
And I'm sure you're right, Judge, but we'll open it really quick and just
Okay,
make sure
sure,
that
absolutely.
our 1 and 3 and 2 and 4 are the same as yours.
One, two, Kristen Banfield, 3, Mr. Brendan. Need 2, no. We doing
Sure.
So,
So 1 and 3?
1 and, no,
No,
no, 1 and 4.
1 and 4.
1 and 4?
1 and 4.
Okay, absolutely, that's fine. Any objection to that, then?
No, Your Honor.
All right, so we're going forward on count 1 and 4 of the case number ending in 666. And then for 2 and 3, there's a motion to dismiss
dismiss.
those.
Oh, wait,
so you have
okay,
no
hold on, I'm
objection to-
getting tapped.
No, ma'am.
Wait a minute, hold
Yeah,
on.
let-
There seems to be a change here.
Sorry, we're gonna read this one more time.
Same after transaction?
Yep,
1.
1.
For Ryan.
Okay. And then
4. Same 3-year period, Christine, yes. 1 and 4. Dismiss
Oh, you're-
2 and 3.
okay.
Yes.
Final answer?
Yes.
Okay. 1 and 4, so we're dismissing 2 and 3 with no objection. Okay?
objection.
All right. So 1, 4, and 5 under the case number 666, and then we just have child endangerment on
Which
the
is,
one ending in 873.
that's
Okay?
count 1, Judge?
That is count 1.
Yes.
So count 2 is dismissed.
Yes, ma'am.
On that, on 873. Okay, fabulous. So now I have the ones before that we had talked about. Do you just want to go through those?
Yes, ma'am.
Okay,
And I will pass up our new stack. They're clean. They have the
Okay,
letters typed
excellent.
in.
all right, so I had instruction A, which I assume is still the same, correct?
Yes, ma'am.
Okay, and then we'll withdraw instruction B since he did
Correct.
testify? Okay, withdrawn. And then you still have C,
Yes.
okay. D,
Yes.
E,
Yes.
F,
Yes.
G,
If they stop sticking together, yes.
all right, and then H.
Judge, I have an I next.
Oh, I'm sorry, H is child abuse, so you're
Yep,
throwing that
so
one.
that would be withdrawn.
Okay, fabulous. All right, and then we have I,
Yes.
okay. Q,
So Judge Q would be withdrawn?
Q is withdrawn, I assume without objection.
Without objection.
Okay, Q is withdrawn. Okay, what do you have next? R?
I actually had an L.
Okay, you had L. I switched them around a little bit because.
That's okay, because they didn't make sense in that order. That's fine.
Well, not to me, but.
Nope, that's A-okay, I can track.
I could,
So
that's fine, I'll just.
if you're on R next, we would withdraw R.
Withdraw R, okay.
We would withdraw S.
I have M next.
Okay,
M
so
as in Mike.
M is in.
Okay. S as in Sam,
S as in Sam would be withdrawn.
okay. N as in Nancy,
Yes,
O,
yes,
P,
yes,
T as in Tango,
yes.
okay. And then I think, let me see, then I have some of his instruction. I think that's all I had for you, so which ones would you like to add to that?
So I have L, which was willful.
Willful, okay, you have L.
I do.
All right, do you have a copy?
I
Well,
do.
You got the clean copies,
Yep,
that's
I'm
fine,
gonna
okay,
pass
so.
that up to Your Honor.
We'll add L, okay, and what else?
And then I have U, which is the instruction for aggravated murder, 3-year period.
Okay,
And then I have V, which is the instruction, aggravated murder, same act or transaction.
okay.
And then I have X, which is the crime of child endangerment.
Child endangerment, okay. And your U and B have the waterfalls also?
They do not, Judge.
You're not doing
We are not
waterfalls.
doing a waterfall.
You are just standing on aggravated murder?
We are.
Okay, that is your option. Do you want waterfall instructions, Mr. Carroll?
No, Your Honor.
No.
Stand on as well.
Okay, so we're standing on aggravated murder. You've just made life a lot simpler for me on your decisions, but that is your decision. Okay, so no waterfalls, we're standing on aggravated murder.
Yes, and I'm passing them up with the previously agreed upon new separate so that you can put them in as you
Okay.
would like them to appear.
All right.
I also understand we've agreed to defense 2, 4, 10, 12, 16, 20, and 36.
I think that's what I have.
No
Let me make
changes.
Sure. That's the only, those are the only ones I had already had, correct?
Correct.
Yes, Your Honor.
I have 2, oh, I do have L, okay, sorry. I do have 2, 4, 10, 12, and 16, and 20, and 36.
Yes, ma'am.
Okay, anything to add to those, or that's it?
No, Your Honor.
Oh, you guys get a gold star today.
Thank you.
Okay, that is fabulous. All right, so you want to hand me up the, you have the clean copies for your, oh, you already gave them.
Yep.
Okay, I got the clean copies. And do those include Mr. Carroll's, or Mr. Carroll, yours were already clean copied, correct?
The ones that I handed up before were clean copies.
Okay, so I can just insert his into
Yes, ma'am.
yours. Perfect.
And
I
at this
can do
point,
that.
we owe you a verdict form. Now that you have accepted those
Right, yes,
instructions.
I have those instructions.
We will provide you with a verdict form.
Okay, oh, that's fine. So if you want to provide a verdict form, I can have Shannon do one since it's just aggravated murder now. It's not too
If,
difficult.
if,
I can do that.
that's just fine.
So we'll do 3 verdict forms, one for aggravated murder, one for firearm, and one for child endangerment.
Yes,
We're on
ma'am.
the same sheet, music? Okay, good. 3 verdict forms?
Ms. Fritzler is asking, do you think we need 2 aggravated murder forms?
Oh, yes,
given
I'm
that there
sorry.
are 2
I
separate?
apologize, you're right, because you did go ahead and do both, same occurrence and 3
And
years.
3
Yes, so we need 4 verdict forms. Aggravated murder in the same act and transaction, aggravated murder in 3 years, firearm, use of firearm, and child endangerment. Okay, we'll get those together.
Perfect, thank you.
And by the end of closings, we'll be able, you can review them before they go back to the jury.
Great, thank you.
Okay?
Your Honor,
Yes,
is
sir.
there an order that you're going to be calling out the jury instructions?
There is. Let me just put it back into the order, and I will let you know. And I will actually get copies to you as well,
Okay,
in the order that I'm going to give them, and I'll get one for the court reporter too, Carol.
Great, thank you.
So I'll do that. We'll have time to do that, okay?
okay.
So that takes care of jury instructions. Do I have Ms. Smith here yet? Ms. Smith, are you here? Are you ready for your motion?
Yes.
Let's go. Is that okay?
Yes,
I'd
absolutely.
rather do that than I can go back and put those instructions all in
Yes, ma'am.
order. Ms. Smith, you can just come to the center podium, that's fine.
Thank you.
Apologize, these were all withdrawn.
Just want to make sure I have the right Miss Smith. This is for the access motion?
Yeah, yes.
Okay, great.
Well, you're Ms. Smith, so.
Well, no, I know.
You
I
answered.
There could be multiple Miss Smiths, so I wanted to make
Well,
sure.
the odds were pretty good that that I had the right person. I know it was set for 9:30, but since we were so organized today, if it's okay with you, I'd like to go ahead and do it now.
Absolutely.
All right, I've read your motion.
Thank you.
So you don't need to regurgitate it, but anything you want to add to the record, you're welcome to.
Oh, thank you. No, I mean, I appreciate you reading it. And just for the record, I'm Alia Smith here on behalf of ABC and NBC for access to sealed records. And I won't repeat what's in our papers, other than to say I read the Commonwealth's opposition yesterday.
Right.
And, I don't think that they offered the compelling reasons that are necessary to seal, in a public criminal trial. But, the fact that the litigation was concluded in the Daily Press case, which is one of the main authorities that we relied on, I don't think is a distinction, because the harm that they're claiming here is not to do with jury tampering or jury impact. And same with they try and distinguish the press enterprises cases because in the press enterprise cases, the Supreme Court was dealing with the sealing of a whole entire trial.
Being closed, correct.
Correct, and that's true. And I appreciate very much that most of this trial has been completely open.
400 exhibits and televised, so.
Exactly, and the exhibits available on the internet. But I think the point of the press enterprise and Globe newspapers and all the Supreme Court cases is that, you know, every aspect of a criminal trial needs to be open, and if it's not, the sealing has to be justified by on-the-record findings of a compelling interest, and I don't think that's been done here.
Okay, all right, thank you, ma'am. Did you want to respond? I did read your opposition
We
brief.
would submit on our brief.
Spin on your brief. Did you want us to respond, Mr. Carroll? You join your microphone, just.
Your Honor, I would join in the Commonwealth's position.
All right, thank you. Okay, you can stay right there. That's fine. All right, so the ruling on the media motion, non-parties ABC and Dateline have moved to unseal certain exhibits admitted during this trial. The court fully recognizes and respects the First Amendment and the fundamental principles of transparency in our judicial system. These proceedings have at all times been open to the public and the media has not been denied access to any hearing or trial testimony in this case. At the same time, the court does not take the sealing of documents lightly. When considering sealing or unsealing, the court must balance the public's right of access against other compelling constitutional and statutory interests. Here, the constitutional and statutory rights of crime victims. Article 1, Section 8 of the Virginia Constitution, entitled Rights of Victims of Crimes, and Code 19.2-11.01, entitled Crime Victim and Witness Rights, require that crime victims be treated with dignity, respect, and sensitivity, and that their privacy be protected to the extent permissible under law. Victims are defined in relevant part to include family members of homicide victims, including spouses, parents, children, and siblings. As the Supreme Court recognized in Globe Newspaper Company versus Superior Court, the First Amendment right of access to criminal trials serves the important purpose of protecting the free discussion of governmental affairs. However, that right is not absolute. It may be limited where there is a compelling governmental interest, and any limitation must be narrowly tailored to serve that interest. The court finds that unsealing these materials would add little, if anything, to the public's understanding of the judicial process, while substantially infringing upon victims' constitutional and statutory rights. Here, the court finds that the protection of victims' rights constitutes a compelling governmental interest. That interest necessarily limits the public dissemination of graphic depictions of deceased victims, nude victims undergoing life-saving measures, and autopsy images, particularly where such materials would be available for permanent public distribution, download, and reproduction worldwide. The First Amendment does not require the court to permit the exploitation of crime victims or their families by releasing graphic images of their loved ones' bodies for purposes unrelated to public oversight of the judicial process. The victims in this case were a mother, daughter, sister, and a son, brother, and grandson. Their surviving family members' constitutional rights must be considered and respected. This remains a public trial. Of the exhibits admitted into evidence, approximately 400 exhibits are unsealed and publicly accessible on the court's website 24 hours a day. 74 exhibits were placed under seal. The court has reviewed each sealed exhibit admitted in this case to ensure that sealing was narrowly tailored and justified. I will note initially that one category of material referenced in the motion, the co-defendants' interviews with the Commonwealth, were never admitted into evidence and are not part of the court's record in this trial or any pretrial proceeding, okay? Those materials remain in the possession of the parties and are not subject to unsealing by the court. Additionally, the minor child's interview was sealed pursuant to a pretrial motion due to the presence of a minor victim, and that sealing remains appropriate. With respect to the sealed body-worn camera recordings, the moving parties requested that the court redact or excise portions depicting victims' bodies and release the remainder. The court received these exhibits in their entirety as evidence. It is not within the court's role or technical ability to edit, splice, or alter admitted evidence, and the exhibits must be considered as they are entered into the record. All sealed exhibits were sealed pursuant to motions agreed to by the parties at the time of admission. For the record, the court will now go through each sealed exhibit and state the basis for sealing. In doing so, the court does find that certain sealed exhibits do not implicate victims' rights and therefore will be unsealed, okay? So I'm gonna go through it and I'll give you a copy of this too.
No, and I appreciate that. And can I just be heard on for one moment on the body-worn camera footage?
You can, but I'm not gonna change my mind.
Okay.
All right, so would you not rather do, okay, good, okay. So let's go through the sealed exhibits. All right, number 4 is a body cam of Officer Hugh. Both victims are shown, one is deceased and one is nude, and life-saving measures are being taken. A recently sealed number 5 is a picture in the far right corner. You can see Mr. Ryan's body. Number 6, Of the Commonwealth's evidence, body cam of Officer Beckner, both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Number 8 is a photo from the still body cam, and it's of the victim's body. Number 9 is also a photo from the body cam of the victim's body. Number 10, the body cam of Officer Gibbons. Both victims are shown. One is deceased and one is nude, and life-saving measures are being taken. Commonwealth's Exhibit 11, the autopsy report will be unsealed. Commonwealth's Exhibit 12, the autopsy report of Mr. Ryan will be unsealed. Number 11 was Ms. Banfield. Number 13 is a photo of Joseph Ryan's deceased. Number 15 is a photo of Joseph Ryan deceased. Number 20 is a photo of Joseph Ryan deceased. 22 is a photo of an autopsy of Ms. Banfield. 23, 24, 25, 27, 28, 29, 30, 31, 32, and 33, and 34, 35, 36, 37, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, and 49 are all photos of the autopsy of Ms. Banfield. Number 58, 59, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 70, and 71, and 72 are all FetLife conversations which will be unsealed. Number 98 is a photo, aerial view of the house, but Mr. Ryan's body is in the photo. Number 9, a photo of Mr. Ryan's body on the floor. 100 is a photo of closer up of Mr. Ryan's body on the floor. 101 is also Mr. Ryan's body. 101A is that same photo with annotations. 101B is the same photo with annotations. 123 is a photo of Joseph Ryan's body. 123A is the same picture with annotations. 123B is the same picture with annotations. 124 is also a photo of Joseph Ryan's body. 170A is a photo of 171 with annotations, which is a picture of Joseph Ryan on the floor, deceased. 172 is a photo of Joseph Ryan's as well on the floor. 174A is that same photo with annotations. 181 is a photo of Joseph Ryan's body. 221 photo is of Joseph Ryan's body. 221A is the same photo with annotations. 241 is a photo of the body-worn camera, a still photo with the victim, Mr. Ryan, on the carpet at the crime scene. As far as defense sealed exhibits, the body cam video of Officer Palmer has the body of both Joseph Ryan and life-saving measures being taken from Ms. Banfield at the crime scene. And number 87 is a body cam video of Officer Casanova without audio, and the minor child victim is present for a significant portion of the video. And 119 is a Gmail log for FetLife, which I will unseal. So I will give you a copy of those, and I'll highlight the ones that I'm unsealing. They're already highlighted.
I appreciate that very much. And just for the record, I'd like to add that in the Knorr case that we cited,
Sure.
The court did order the availability of redacted video and documentary records. And in the AP case from the Fourth Circuit, the court held that administrative burdens are not a sufficient compelling reason to keep things. And so I really feel like, there's a way that public can have access to some of this, even if they don't have the specific, very graphic images.
And the exhibit is the exhibit, and I take the exhibit as it is. All right? Thank you very
Understood.
much for
Thank you,
your
Your
motion,
Honor.
and have a good day, Ms. Smith. All right, do we have anything then until 10 o'clock?
No, ma'am.
All right, I will go ahead and get the instructions put together in the order I'm going to do them, get a copy of them, and if you want to stay here, I'll get you the copies so you can be prepared for your opening statements, okay?
Thank you.
All right, thank you. All rise.